Hey, my name's Matt Marcellino. Thanks for tuning in again with the Marcellino and Tyson podcast. I'm sitting here with Clay Campbell. He's a partner here in our office. He does civil litigation. We're about to talk about what's called a motion for summary judgment. If you saw the prior podcast, is about a motion to dismiss. Motion to dismiss what? The complaint, typically a lawsuit or a cause of action in a civil litigation matter. That was the other podcast that predated the motion to dismiss. Motion for summary judgment, uniquely different. This one's a little bit more difficult for some people to wrap their brains around. So boil it down for me like I'm a 5-year-old.
So the motion to dismiss only looks at the complaint.
Yep.
The motion for summary judgment looks at everything that the parties have done up to the filing of that motion. So it can be depositions, it can be documents.
But what are they looking for?
So whether the facts support the claims. Okay. And when I file a motion for summary judgment, I'm telling the judge, the facts are clear. We all agree that, back to our previous example of the car wreck, we all agree that the wreck happened, except Mr. Marcellino admitted during his deposition that he had never gone to the doctor, never suffered a headache, never treated, didn't miss a day of work, didn't have any damages at all. So even if the wreck happened, even if it was my fault, he didn't suffer anything, and for there to be a cause of action, he's got to have damages. Judge, throw the case out.
So the motion to dismiss based on a complaint being essentially improperly drafted, right? Somebody left out a very important detail, again, a buzzword that's an element that's necessary to prove the claim. So the motion to dismiss says the complaint is faulty and it should be kicked out, correct?
That's right.
All right, but in the motion for summary judgment, that's not available because the complaint has all the buzzwords, but there's disputed allegations.
No. There are no disputes. You can't have any disputes as to fact for summary judgment.
How do you get to a fact?
So the fact is the car wreck happened,
Right.
right? Maybe the car wreck didn't happen. There was no actual collision between the vehicles, and we've got proof of that. Or you were damaged as a result. Well, you admitted during your deposition that you weren't. So we've taken the allegations. Both parties have said what they want to say about them, but then we have the evidence that's going to back it up. What the jury would eventually hear if it were to go to trial. And we put that in front of a judge and say, Judge, based on what everybody agrees to be the facts, this is the outcome that you must reach.
So essentially, the undisputed facts do not support that a lawsuit should continue.
Exactly.
Okay. So again, even if I pled my complaint against you with our car accident hypothetical correctly, but then I went to a deposition, to your point, I said, I actually was never hurt.
Yes.
I felt no pain. I have no damages. And because that deposition is a sworn statement under oath, that creates a fact.
That is the fact. That is the controlling fact in that case.
But it wouldn't have been a fact up until the point that I deposed. You took my deposition.
Exactly, because I wouldn't have known it otherwise.
That comment creates an undisputable fact that torpedoes my lawsuit.
Yep.
Okay. So you said earlier, when everyone agrees upon the facts, do the parties always agree that facts are facts when you go to a summary judgment hearing?
Not always, but if the parties don't agree, oftentimes you're going to be able to create an issue of fact for the judge, which means the judge can't grant summary judgment. Okay. That's why summary judgment is pretty rare, especially in a negligence case.
So motions to dismiss are very unlikely to prevail, right?
Yes.
Motions for summary judgment, how likely are these to be successful?
Depends on the case. I mean, especially contract claims, you can start getting rid of those. I've been successful with some negligence claims, getting rid of those, but there is still not that likely. The case law favors letting it go forward.
Okay. Better than a motion to dismiss. The likelihood is better than a motion to dismiss.
I think so.
But still not incredibly high. Right. It has to be abundantly clear that one cause of action or an element within that complaint no longer exists.
Exactly. Yep.
Okay.
There's something is fatal is the word that often gets used. Something kills that claim, that cause of action.
Is it possible to go to court? Let's say that you contend that what my deposition testimony was, I said I suffered no damages, right? We go to court and you say, Judge, these are facts. Matt said during his depo he wasn't injured, right? But let's say my attorney says that's not what he said, right? Does the judge have the ability to look at the deposition transcript and say, actually, I believe with Clay, that is what Matt said, that establishes a fact that therefore torpedoes his claim?
Yeah. So the judge is going to look at the transcript. I'm going to make sure that the judge has a copy of that, or at least an excerpt from it, so that he can or she can see, word for word what you said. And if you said, I didn't suffer any damages, I don't know how you run from that.
Right. Okay. So it doesn't require an agreement of the parties that there are facts. You can still have disputed allegations, but you contend the allegation is now a fact,
Right.
or the omission of it is a fact, and the judge can agree with you and then make the ruling from there,
Yes.
and then kick out my lawsuit. And that can be done after discovery. At any
Typically,
point in time.
yeah, you typically need all of that information to support the motion for summary judgment. To
Understood. So you're gathering a ton of information after the lawsuit's been filed to establish whether or not you can file a motion for summary judgment to have it kicked out.
That's right.
Okay.
And it's all still guided by that end,
The complaint, the allegations in the complaint. All right, cool. All right. Well, thanks for explaining that one to me. Totally different, because in our line of work, are there really any ever facts that people agree upon? Very rarely, other than names.
right.
Maybe where the action should be filed, but not always, right?
Not even that always.
But most of the time, facts are always disputed. That's why we call them allegations, and we fight over allegations until the judge says yay or nay on something, right? Okay. All right. Well, that's a motion for summary judgment, different than a motion to dismiss, both based upon the pleading called the complaint. That is the beginning of the entire civil litigation process. Hopefully this was helpful to you. Again, just so we're all aware, like everybody's case is uniquely different, right? That's why we call them allegations. They're particular to you. This is not legal advice. We're just trying to explain the process that you can explore. Attorneys should know, most of them do, we do, when to file these motions. So you can have conversations, obviously, with your attorneys about these sort of options. They're not always available. It sounds like they're not even really that likely to succeed, but they should be explored, is what I hear Clay saying. But hopefully this has been helpful with regard to another way to potentially get rid of someone's lawsuit against you, i.e. the complaint. Thank you again for tuning in. See you at the next podcast about who knows what.